Hi folks, Attorney Kip from Malik Malik talking about a new pretty important case that's going to impact you called Dillon versus the Industrial Commission. In essence, in the past, if you had found to be reached max medical improvement, you would continue to receive temporary total disability until you were found at a hearing to have reached the MMI. So there might be a doctor's examination, either an independent medical evaluation that said, hey, this individual's reached maximum medical improvement. The employer would file a motion, and then that finding of MMI would go to a hearing, and then as of the date of that hearing, if they found that you'd reached MMI, then your temporary total would be terminated. And that's how it would work in the past. So you would continue to receive temporary total disability up until the date of that hearing if they found you MMI at the hearing. And if you don't know what MMI is, basically max medical improvement. It doesn't mean you're healed, but you're not getting better. You're not getting worse. It's your injuries or the allowed conditions of your claim have reached like this treatment plateau. And so basically what that means is you're no longer entitled to temporary total disability compensation. So in the past, you continue to receive temporary total disability compensation up until the hearing that found that you had reached MMI. Now, with this Dillon case, or what it seems to be saying, and we'll see how it plays out with subsequent hearings, is that if your employer, for example, let's say your employer has you examined on January 1st, in an independent medical evaluation, or there's like a 90-day extended disability exam, and that doctor in that extended disability exam or IME finds that you've reached MMI, then what is happening now, or at least according to this case, is that at the hearing officer, so that might have occurred, let's say, for example, February 1st, this examination occurred. You don't have your hearing until May 1st, for example. So you're continuing to be certified by your doctor for temporary total disability, and you'll continue to receive comp. And then when you get to that hearing, if the hearing officer finds that you have reached MMI based upon, and let's say that hearing is on, again, May 1st, if the hearing officer says, oh, you're MMI as of the IME or examination that took place on February 1st, well, then you have an overpayment from February 1st to March 1st to April 1st, all the way up to the hearing of May 1st. So you have an overpayment on your claim. And so what that means is if you have an overpayment, you got to pay that money back. And so that's massively different than the way it was before. In the past, you would continue to receive comp, and then you found MMI, your comp's terminated. Now you're found MMI and you have an overpayment. And you might be thinking, well, I'm still getting the money. That's fine. But in some instances, that's it's a kind of a problem, because if let's say you get another condition added to your claim, then you might get your comp might get restarted based on that new condition, but you might have to pay back this overpayment. Or let's say you want to settle your claim, and now you have this overpayment that you have to pay back. And the problem is sometimes when you're settling these cases, sometimes the BWC or whatever, they'll waive the overpayment. Sometimes they don't. So let's say you have a $5,000 overpayment. The problem with that is if you have a $5,000 overpayment, let's say you want to settle, and then the settlement is $10,000, and they're not going to waive the overpayment. So now it's a settlement for $10,000, but if they don't waive the overpayment, then you might have to, that might be 10,000 minus, $5K. So the settlement that you might actually, it might be a $5K settlement in the way it's really kind of working. So this is this Dillon case. And so what happened is this individual, just to go on the facts of this case, this individual, April 2nd, 2019, this Dillon was pushing and stopping carts, and that resulted in a work injury. And so she filed for a claim. The BWC issued an order allowing for lumbar sprain strain. The employer appealed. And then during this time, Dillon's physician of record, I guess this guy's name is Dr. Edge because he's so edgy, certified Dillon from April 2019 up through December of 2019 for the lumbar sprain strain. And prior to the district hearing hearing on the initial allowance of the claim, she also subsequently requested that her claim be additionally allowed for a disc displacement and annular tear. So sometimes we'll just pursue like lumbar strains at these initial allowance hearings. This person, I guess they really wanted to get this disc displacement and annular tear, and maybe they had all the evidence for that condition, so they're gonna go for the full Monty at this DHO. So at the DHO, remember this happened April 2nd, 2019. The DHO was June 13th of 2019, and it was an initial allowance hearing. So it was an initial allowance hearing, they're requesting comp, and they're requesting these additional conditions. So the district hearing officer granted comp from whatever, April to the date of the hearing and continue. They granted the lumbar sprain strain, but they denied the disc displacement annular tear. And I think, I can't recall if the claimant appealed, but presumably the claimant would have appealed, but the employer may have appealed as well. But nevertheless, what ended up happening is this person continues to get comp, they continue to get comp, and then on April 8th, 2019, they're examined by the employer's independent medical evaluation by Dr. Steinman. And if it's the same Dr. Steinman that I'm thinking about, I think this guy has a background in child or infant neurology. So question whether this individual is qualified, but that's a discussion for another video to opine about back issues in adults, but nevertheless. Anyways, so he found that this person had reached MMI for the lumbar strain, issued a report. Again, the date of the examination is August 8th, 2019. So DHO, June, finally gets to the hearing in October 28th, 2019. So the district hearing officer allowed the claim to remain allowed for the lumbar sprain strain, denied the claim for disc displacement and annular tear, and then granted comp from April 8th, or from April 2019 until August 8th, 2019, finding that the injured worker had reached MMI based upon the report of Dr. Steinman as of, April 8th, 2019. So what ended up happening is there was an overpayment declared because the injured worker Dillon continued to get it comp from August 8th through the day of the hearing, August 29th, 2019. And that overpayment was $5,549.40. So that's not great. And nobody wants an overpayment. So the attorney for Dillon filed a request for reconsideration. Then ultimately they filed a mandamus action to the 10th District Court of Appeals and the 10th District. And the argument was they're relying upon, in the past, the prior precedent or whatever was this Russell case. And again, the Russell case said, hey, comp's not terminated until you're found MMI as of the hearing. So the hearing is when the comp is terminated, and then obviously the employer is saying no, it's of the date of the examination. So, but they kind of split hairs in the 10th District, and they basically said the Russell decision commission may not declare an overpayment before the date of the hearing, finding claimant has reached MMI. So that's what I've been talking about. But they're saying Russell involved termination of established temporary total disability award. So basically they're saying, hey, this person had been granted comp, and this basically the employer had filed a motion to terminate comp, and that's how that should work with the Russell case. This is different because this is an initial award of period of comp, and so Russell's not really relevant. And so I think the employer appealed that to the Supreme Court, and the Supreme Court kind of took a different tact, and they kind of essentially threw out Russell. At least that's kind of how I'm reading it. Now other people argue differently. Obviously the dissent is pretty strongly against the throwing out of Russell or overruling Russell in this decision. But the Supreme Court basically said they're relying on this 412351K, which basically says, and this is Ohio Revised Code 412351K, which basically says if an injured worker received comp under a prior order and that order is reversed, then an overpayment. So that's what 41235111K says. So if you get comp under like a DHO order and then the SHO order, it reverses that, then there's an overpayment. And then as regarding Russell, So Russell said a claimant who has received an award of temporary total disability remains entitled to receive payments for the purposes of revised code 4123 511K until temporary total disability is formally terminated. And the Supreme Court is basically saying, but that's kind of in conflict with Ohio Revised Code 4123 56A, which says temporary total disability comp may not be paid for the period after the employee has reached maximum medical improvement. So that's how they're throwing out Russell, and they're saying Russell's kind of ignoring 4123 56A. So the period after the employee has reached MMI. And so if the doctor examines you, again, in this instance, on August 8th, 2019, it says your MMI on August 8th, 2019, pursuant to this Dillon decision, if you continue to receive comp after that, that's an overpayment, which it's kind of, again, not really great for injured workers. It's going to lead to overpayments for a number of people. And the dissent wasn't crazy about the decision as well in this case. And so when you read these Supreme Court decisions, there'll be a majority, occasionally there'll be a dissent. And in this instance, there was a dissent. And they basically said, nobody was wanting to throw out Russell. The employer and the IC wasn't necessarily wanting to throw out Russell, and nobody really asked for that. And the injured worker wasn't asking Russell, this prior case law, to be thrown out. But essentially the majority threw out 25 years of precedent, and precedent means like for instance, we all know Roe v. Wade. So Roe v. Wade was a precedent forever, and then that's changed with the Supreme Court of the United States. So that's precedent. What the prior law, and you would follow the prior law, you're following precedent. And that's kind of how, if the court has made a decision in one way, then the idea is the court is supposed to continue to follow how it was previously decided. They're not supposed to just make these drastic changes to case law without reason. I mean, there's got to be a substantive reason to throw something out the window. And Russell was a Supreme Court case. And that's not how laws aren't supposed to change that way, because when Supreme Courts do that, they're basically making law. They're not interpreting law, is kind of the danger of that. So the dissent lays out the three factors when it is okay to throw out precedent. So when these three things are in place, then it's okay to throw out precedent, and the dissent is saying that wasn't the case here. And the first factor is decision was wrongly decided at the time, or changes in circumstance no longer justify continued adherence to the decision. Really nothing's changed to make the continued adherence of Russell workable, beyond the fact that employers don't want injured workers to get additional periods of comp. Obviously, I mean, let's face it, if all things being equal, let's try to make things as, it's all about maximizing money, really. And so the second thing is the decision defies practical workability. And again, not the case, because that's how the Industrial Commission had been interpreting Russell as far as the MMI in the past for, again, 25 years. So it was workable, it was practical, and it was workable. And then abandoning the precedent would not create an undue hardship for those who have relied upon it. So, and that is not the case here, because if you're an injured worker, and the thing is, it would be one thing if there was like a super, quick turnaround for, like, let's say you have Dr. Steinman finding this injured worker MMI as of, August 8th. And then August 9th, you had the SHO hearing. That might be okay, because then you're not having this overpayment. But the way things work at the Industrial Commission, the BWC, and all these things, it's like, things are continued, and there's only so many hearing officers. So you might have an IME finding that's like months old. And the other thing is with if you're going to trial, like when you go to a 512 trial, when you're trying to get your claim allowed, or have additional conditions, you're allowed to cross-examine this doctor. You're allowed to request, like you could request Steinman's qualifications. You could request Steinman's, for instance, in this case, how many of these things do you do this for this employer? oh, I do 90% of my work is for employers. I make millions of dollars every few years. I don't know if that's the case with Steinman, but I'm just saying as an example, you know, there could be you could make an argument that there's bias in his decision. You could make an argument, and you know, that this doctor, whomever it might be, might not be qualified to make that decision. You might be able to show that they don't have all the facts and details around the injury to make a reliable opinion based of MMI. So if it was a trial setting, you have that opportunity to cross-examine the doctor. But when it comes to administrative hearings, they do the IME, and that's that. And the reality is, a lot of these IME doctors, it's like frequent flyers. A lot of these folks, it's like they make a lot of money doing this. This is a lot of them. I mean, not a lot of them, but some of them are retired from the practice of medicine, and what they're doing is independent medical evaluation. So if you have a bunch of these IME doctors who are more or less, if they're making 90 to 89% of their decisions for the defense or the employer or the BWC adversely against injured workers, that's a very biased position to have. And that in conjunction with this Dillon decision creates problems for the injured workers when they have these overpayments. So it's not a great case. And that's, one final thing before I let you go. I mean, that's why we vote for these Supreme Court justices in Ohio. It's important, and for your judges and whatnot. It's important to vote for the judge and the justice who's going to protect, your rights and your benefits and these things, and who finds, I think Russell, I think that works, and I think it's a good way to handle things, and I do want to protect the injured worker and not put this burden of this overpayment versus this is unfair or whatever to employers or what have you. So you want to vote for folks who are going to protect your interests. So really focus on what is important to you. How is that going to impact you? I wouldn't always get wrapped up into some of these things that people think are important aren't always the things that are important, and the things that are important are the things that are really important, that are really going to impact you, like your benefits being reduced. That's going to impact you if you rely on these sorts of things. So point being is, your vote has an impact on how things turn out, because these are the people that decide on these things, and these are the people that, again, decide to throw out 25 years of prior precedent, as the dissent laid out in this case. So not a great situation. It's not totally worked through the Industrial Commission. We'll see how things spin out, but it's kind of like the precision excavating case, how that was kind of had a bad impact on injured workers, and then we had the law change as a result of that precision excavating, and that had to go through the Industrial Commission and 10th District cases, how that 412356, I think F it was, how that is being interpreted. And so it seems like it's starting to solidify how that's being interpreted, but this is a new thing, and it could inversely impact you. So that's Dillon versus Industrial Commission. I'll put the link to the Supreme Court decision, so you can click on that, download it, read it, and you should. I mean, if you have the time, and then read the dissent, and then if you have any questions, comments, etc., as always, either comment, email me, call our office, and as I say at the end of every one of these videos, workers' comp in Ohio is super, super duper complicated and intricate, so do not do this stuff alone. Ask your friends, relatives, colleagues, hey, who's a good workers' comp attorney, or who do you recommend, or who have you worked in the past? If that doesn't work, do a search on Google. Talk to one workers' comp attorney, talk to 10. find the one that works for you, that you trust, and go with that person. So, but I do recommend you get a workers' comp attorney if you have a work injury. Stay safe and good luck, and thanks for watching this video. Bye.